Eskom has argued that the Mpumalanga High Court sanctioned an illegality by ordering it to reinstate uninterrupted electricity supply at Sonae wood panel manufacturing plant. It says the order compels it to act contrary to its license conditions and its responsibility to implement load shedding in emergency situations where demands exceed supply. The power utility contends that Sonae benefited from an unlawful exemption from load shedding for over 2 years. It says there was no legal basis to exempt the factory based on an oral agreement when there is a requirement for written agreements in such instances.
We say the High Court erred in this regard because even as a starting point, the mainstay of the respondents' invocation of the doctrine of legitimate expectation was an agreement it purportedly entered into with the municipality. But as we showed throughout our papers, that agreement was illegal. First, it failed to comply with the requirements of the code, which prescribes that such agreements for load curtailment must be strictly in writing.
The Mbombela Municipality has disputed the existence of an oral agreement between itself and the Mpumalanga-based factory to supply the company with interrupted electricity. The municipality also submitted that the company failed to prove the existence of oral agreement. It wants the Mpumalanga High Court order to be overturned.
On the facts that are there on the applicant's version, there is no agreement until the 9th of June 2023. So on what basis, in fact and in law, can one say there was an agreement between the parties, between municipality and Sonae? If Sonae itself, on its own version, produces documents that point to an agreement that had terminated, that the municipality had not exercised a right to reinstate it, So we submit that on their own version, there was never an agreement.
Sonae has argued that stopping power supply at its operations had nothing to do with grid stability. It says the issue was between Eskom and the municipality, which had failed to provide reports to the power utility for 5 months. The company argued that it had operated without interruption for 2.5 years before Eskom implemented load shedding at its operations.
We are simply sitting with a situation where Eskom weren't provided with reports and they said, you know what I'm going to do is I'm going to affect load shedding and I'm going to change the status quo that has existed for 2.5 years. Why? Because you didn't give me my reports. What did the municipality say? And that is where we asked the additional evidence to be submitted. The municipality said, we can't give you reports, we don't have measuring instruments.
The company contends that load shedding creates a real and substantial risk of fire at the factory. The SCA has reserved judgment. Mpumalanga, SABC News, Bloemfontein.